Beep, beep, beep. Welcome to the court of the EDI jester. Here we go. Got the cough coughs. Cough coughs. The cough coughs. How are you? Right? What's going on? Well, we have some good news. Some good news today, afforded me by the marvellous Kara Dansky, who's doing fantastic work in America on the problems we know exist with gender claptrap and woo-woo, okay? So we've got Kara Dansky today. First of all, subscribe, like. Like's important. I've read now. Like's important. Like, subscribe, put your notifications on. But most of all, come and be a warrior teacher, right? Starts March, third week in March. So we've got a bit of time to get everybody on board. Need the numbers and come and it's fun. All right, that's the best bit. It's fun and informative. So, come and have a go. Come and have a go. If you've got any questions, ask me them on Twitter at HeadWarriorTWM, so I can answer them for you. But let's go. We're going to the Americals. Oh, say, all the usual. What a lovely voice. That was Bane, wasn't it, in Batman? What a lovely voice. He had a very strange voice, didn't he? And that little boy singing, and they promptly killed him. Bane. A case has settled. Kara informs us that a case has settled, resulting in a major win for students and parents who don't wish to affirm people's gender identities. This is very important. Now, link in the doobries to Kara's tweet, which is it's a thread of tweets. So go and have a look. This case is Parents Defending Education versus Lynn Marr. And they've got there a Twitter handle for @DefendingEd, which is the group of people who are involved in this particular important case over in America. This is in Iowa, land of the potato. Or is that Idaho? I forget. The Lynn Marr School District in Iowa had adopted a policy setting forth regulations for the district that address the needs of transgender students. Gender expansive students, make them sound like a balloon. What do you do? Blow them up with a tube up their backside. Ear burst, careful. Gender expansive students, non-binary, gender conforming, you get the idea, right? All these nutters. And also students questioning their gender to ensure a safe, affirming, there's the word, affirming, we know what that word means, affirming and healthy school environment where every student can learn effectively. It said an intentional or persistent refusal by staff or students to respect a student's gender identity is a violation of school board policies. Now that's an interesting policy, isn't it? So what it's saying is this person who says they're something they're not, you must respect that. And if you don't respect it persistently, we're gonna, have you done. New to you, or whatever it is they would have done to them with their punishments. We see these sorts of things popping up all the time. Imagine if somebody had said to them, right, okay, I'm Napoleon. And they'd gone, yeah, you will affirm Napoleon here. If you don't affirm Napoleon, then we're going to come get you. Nonsense. The plaintiffs were a group of parents with a variety of concerns, some who were worried that their kids, who were on the autism spectrum, might decide that they are transgender without the parents' knowledge. Others don't believe in gender identity and didn't want their kids to have to go along with other kids' gender identities. The former group argued that the policy violates their right to direct the care, custody and control of their children. The latter group argued that the policy violates their children's right to freedom of speech. They lost at the district court level and appealed to the 8th Circuit Court. In the meantime, Iowa enacted a law that prohibits a school district from knowingly giving false or misleading information to parents regarding their children's gender identity, i.e. preventing these nefarious educators and teaching nincompoops that they do not have the right to not tell the parent if the child is transideated, which is a sign of something much more serious underneath. It's not an actual thing, because there's no such thing as there as trans. So the court decided that the former group of parents' concerns had been addressed by the legislature and their complaints were now moot. Great word, moot. It's moot, which means it's been done already. You don't have to worry about it now. The parents disagreed. I'm with the parents here, says Kara. One of the parents said, Their son wants to state his belief that biological sex is immutable. disagree with another student's assertion about whether they are male or female, and state that a biological male who identifies as a female should not be allowed to compete in women's sports, and express discomfort about sharing bathrooms with teachers or students of the opposite biological sex. Opposite sex will do. Because of the policy, however, the parent stated that her son remains silent in school when gender identity topics arise to avoid violating the policy that the school had put in place. Are you with me so far? The parent also argued that her son's proposed activity concerns political speech and is arguably affected with a constitutional interest bumping up there against the right to free speech. The Eighth Circuit ruled that the parents were entitled to have the policy blocked because they were likely to succeed on the merits of their arguments that the policy is unconstitutionally vague and interferes with their children's free speech rights. In other words, the Eighth Circuit Court of Appeals ruled that public school students have the right to say they don't believe in gender identity. Right? We need more of this across Australia, New Zealand, the UK, everywhere. Let's get more of this going so that we can, ignore these people and tell them what they are and stop having to deal with their fantastical nonsense because they all live in fantasy land, right? It's so good. It's so good. The matter has now settled, and the school has agreed to rescind and not reinstate the policy. Well done at Defending Ed, which is the link to the people that were involved in this case, so that you can go and explore it some more. Go on, it's a win, isn't it? Tell me it's a win. I think it's a win. Is this to you, and I think there is there, perhaps Maya will tell us, is this to you similar to a kind of Forstater hearing? Maya, Forstater, twisted Forstater, all that, right? Is it similar to this? Does that sound similar to you? In Maya's case, the right to believe and to express it was held to be woriads, W-O-R-I-A-D-S, woriads, or worthy of respect in a decent society. Right, woriads. Okay, so that's what happened in Maya's case. Is this a similar thing, or do you think this goes further and in fact codifies the ability of people to blatantly speak the truth and not to be held by anybody else to not be able to, which in this case would have been the school? But many questions must be asked, surely, of how the schools allowed this to happen in the first place. And thousands more of these little bureaucratic hobgoblins, nonsense policies are in fact still in action, still in place across the USA. So I don't think this provides a precedent. I think this is a standalone Iowa thing, which is not the place where the potatoes are. That's Idaho. But nevertheless, to Cara Dancy, great, thank you, and thanks to Defending Ed. Please do go and visit the website that's in Cara's marvellous thread. These people deserve our thanks because this is yet another chip away at the enormous turd stuck in the human YouTube, which is gender identity, ideology, and queer theory. So I'm having it. It's a win for all of us. I'll see you later.